Rule 801, definitions. Rule 801, definitions. Article 8, hearsay. The following definitions apply under this article. A statement. A statement is 1, an oral or written assertion, or 2, nonverbal conduct of a person if it is intended by him to be communicative. B, declarant. A declarant is a person who makes a statement. C, hearsay. Hearsay is a statement other than one made by the declarant while testifying at the trial or hearing offered in evidence to prove the truth of the matter asserted. D, statements, which are not hearsay. A statement is not hearsay if 1, prior statement by a witness. Prior statement by witness. The declarant testifies at the trial or hearing and is subject to cross-examination concerning the statement, and the statement is A, inconsistent with his testimony, or B, consistent with his testimony and is offered to rebut an express or implied charge against him of recent fabrication or improper influence or motive, or C, one of identification of a person made after perceiving him, or 2, admission by party opponent. The statement is offered against a party and is A, the party's own statement in either an individual or a representative capacity, or B, a statement of which the party has manifested an adoption or belief in its truth, or C, a statement by a person authorized by the party to make a statement concerning the subject, or D, a statement by the party's agent or servant concerning a matter within the scope of the agency or employment made during the existence of the relationship, or E, a statement by a co-conspirator of a party during the course and in furtherance of the conspiracy. The contents of the statement shall be considered, but are not alone sufficient to establish the declarant's authority under subdivision C, the agency or employment relationship and scope thereof under subdivision D, or the existence of the conspiracy and the participation therein of the declarant and the party against whom the statement is offered under subdivision E. Rule 802, hearsay rule. Hearsay is not admissible except as provided by these rules or by the civil and criminal procedural rules applicable to the courts of Colorado or by any statutes of the state of Colorado. Rule 803. Rule 803, hearsay exceptions. Availability of declarant immaterial. Availability of declarant immaterial. The following are not excluded by the hearsay rule, even though the declarant is available as a witness. Number 1, spontaneous present sense impression. A spontaneous statement describing or explaining an event or condition made while the declarant was perceiving the event or condition. Number 2, excited utterance. A statement relating to a startling event or condition made while the declarant was under the stress of excitement caused by the event or condition. Number 3, then existing mental, emotional, or physical condition. A statement of the declarant's then existing state of mind, emotion, sensation, or physical condition, such as intent, plan, motive, design, mental, feeling, pain, and bodily health, but not including a statement of memory or belief to prove the fact remembered or believed, unless it relates to the execution, revocation, identification, or terms of declarant's will. Or terms of declarant's will. Statements for purposes of medical diagnosis or treatment. Statements made for purposes of medical diagnosis or treatment and describing medical history or past or present symptoms, pain or sensations, or the inception or general character of the cause or external source thereof insofar as reasonably pertinent to diagnosis or treatment. Number 5, recorded recollection. A past recollection recorded when it appears that the witness once had knowledge concerning the matter and A, can identify the memorandum or record, B, adequately recalls the making of it at or near the time of the event, either as recorded by the witness or by another, and C, can testify to its accuracy. The memorandum or record may be read into evidence, but may not itself be received unless offered by an adverse party. 6, records of regularly conducted activity. A memorandum, report, record, or data compilation In any form of acts, events, conditions, opinions, or diagnosis made at or near the time of or from information transmitted by a person with knowledge if kept in the course of a regularly conducted business activity, and if it was the regular practice of that business activity to make the memorandum, report, record, or data compilation, all as shown by the testimony of the custodian or other qualified witness, or by certification that complies with Rule 902.11 or Rule 902.12, or a statute permitting certification unless the source of information or the method or circumstances of preparation indicate lack of trustworthiness. The term business as used in this paragraph includes business, institution, association, profession, occupation, and calling of every kind, whether or not conducted for profit. Number 7, absence of entry in records kept in accordance with the provisions of paragraph 6. Evidence that a matter is not included in the memoranda, reports, records, or data compilation in any form kept in accordance with the provisions of paragraph 6 to prove the non-occurrence or non-existence of the matter if the matter was of a kind of which a memorandum, report, record, or data compilation was regularly made and preserved unless the sources of information or other circumstances indicate lack of trustworthiness. 8. Public records and reports unless the sources of information or other circumstances indicate lack of trustworthiness. Records, reports, statements, or data compilations in any form of public offices or agencies setting forth A, the activities of the office or agency, or B, matters observed pursuant to duty imposed by law as to which matters there was a duty to report, excluding, however, in criminal case matters observed by police officers and other law enforcement personnel, or C, in civil actions and proceedings and against the government in criminal cases, factual findings resulting from an investigation made pursuant to authority granted by law. Number 9, records of vital statistics, records or data compilations in any form of births, fetal deaths, or marriages if the report thereof was made to a public office pursuant to requirements of law. 10. Absence of a public record, testimony, or a certification under Rule 902 that a diligent search failed to disclose a public record or statement if A, the testimony or certification is admitted to prove that I, the record or statement does not exist, or I, a matter did not occur or exist if a public office regularly kept a record or statement for a matter of that kind, and B, in a criminal case, a prosecutor who intends to offer a certification provides written notice of that intent at least 14 days before trial, and the defendant does not object in writing within 7 days of receiving the notice, unless the court sets a different time for the notice or the objection. 11. Records of religious organizations, statements of births, marriages, divorces, deaths, legitimacy, ancestry, relationship by blood, or marriage, or other similar facts of personal or family history contained in a regularly kept record of a religious organization. 12. Marriage, baptismal, and similar certificates, statements of fact contained in a certificate that the maker performed a marriage or other ceremony or administered a sacrament made by a clergyman, public official, or other person authorized by the rules or practices of a religious organization or by law to perform the act certified in purporting to have been issued at the time of the act or within a reasonable time thereafter. 13. Family records, statements of fact concerning personal or family history contained in family Bibles, genealogies, charts, engravings on rings, inscriptions on family portraits, engravings on urns, crypts, or tombstones, or the like. 14. Records of documents affecting an interest in property, the record of a document purporting to establish or affect an interest in property as proof of the content of the original recorded or filed document and its execution and delivery by each person by whom it purports to have been executed. If the record is a record of a public office and an applicable statute authorizes the recording of documents of that kind in that office. 15. Statements and documents affecting an interest in property. A statement contained in a document purporting to establish or affect an interest in property if the matter stated was relevant to the purpose of the document unless dealings with the property since the document was made have been inconsistent with the truth of the statement or the purport of the document. 16. Statements in ancient documents. A statement in a document that was prepared before January 1st, 1998 and whose authenticity is established. 17. Market reports, commercial publications, market quotations, tabulations, lists, directories, or other published compilations generally used and relied upon by the public or by persons in particular occupations. 18. Learned treatises. To the extent called to the attention of an expert, witness upon cross-examination or relied upon by him in direct examination, statements contained in published treatises, periodicals, or pamphlets on a subject of history, medicine, or other science or art, established as a reliable authority by the testimony or admission of the witness or by other expert testimony or by judicial notice. If admitted, the statements may be read into evidence and may be received as exhibits as the court permits. 19. Reputation concerning personal or family history. Reputation amongst members of his family by blood, adoption, or marriage, or among his associates, or in the community concerning a person's birth, adoption, marriage, divorce, death, legitimacy, relationship by blood, adoption, or marriage, ancestry, or other similar fact of his personal or family history. 20. Reputation concerning boundaries or general history. Reputation in a community arising before the controversy as to boundaries of or customs affecting lands in the community, and reputation as to events of general history important to the community or state or nation in which located. 21. Reputation as to character. Reputation of a person's character among his associates or in the community. 22. Judgment of previous conviction. Evidence of a final judgment entered after a trial or upon a plea of guilty or nolo contendere. Adjudging a person guilty of a crime punishable by death or imprisonment in excess of 1 year to prove any fact essential to sustain the judgment, but not including when offered by the government in a criminal prosecution for purposes other than impeachment, judgments against persons other than the accused. The pendency of an appeal may be shown but does not affect admissibility. 23. Judgment as to personal, family, or general history or boundaries. Judgments as proof of matters of personal, family, or general history or boundaries essential to the judgment if the same would be provable by evidence of reputation. 28. Transferred to Rule 807. Note, Rule 803, 16 statements in ancient documents is amended effective July 1st, 2021, and the above rule uses the new language. Rule 804. Rule 804. My God, the 800s just go on and on and on. We'll come back to 804. We'll come back.